Lawyers, recall the moment a client's giant ego hijacked testimony and handed victory away. Story 1. Literally every time. I sat in a criminal court every day for a year, and more than 75% of those who were found guilty would not have been there if they had exercised their right to remain silent. Also saw a guy who wanted to exclude evidence that he was a member of a gang, but got his motion denied because he had the name of the gang tattooed on his face. Edit, another one. A woman repeatedly said she couldn't remember various things, and said she was on a medication that affected her memory. People not recalling things is pretty common, but they usually don't have a reason like that. Didn't turn out so well when the government played a wiretap of her, saying she was going to claim she didn't remember, and blame it on her medication. Comment 1. I know you probably can't disclose details, but what level of crime are you at that the government is wiretapping you, but you're still foolish enough to be chatting with friends saying, yeah, I'm just going to tell them my medication is affecting my memory, and I didn't rob that bank. Is crime way easier than I thought? Lots of thoughts going through my mind. If you don't hear from me, I'm on my island, Kittenville, United State of Nunya, after I robbed those banks. Comment 2. Reminds me of an old coworker of mine. He ended up in jail for a domestic abuse charge. When he went to his bail hearing, they just asked him if he had anything to say for himself, and his response was, forget all of you. He was brought back into jail for contempt of court. Not long after that, he passed away in his cell. Story 2. I saw a video of a girl who had a $5,000 fine flipped off the judge, so he increased it to $10,000. When he told her this, she told him to forget off, and then she received 2 months in jail. Comment 1. This should really not be legal. This essentially makes the penalty for insulting an individual $5,000, which is absurd. There should be no penalty ever for giving anyone the finger. Comment 2. It's impossible to view it this way. There is likely a maximum penalty that she had not reached yet, and her poor behavior in court suggested she was not worthy of a smaller fine. Comment 3. We accept it because we consider that generally the court must be respected, and there is a certain level of discretion afforded the judge. That said, this is a clear retaliation for speech by the government. It cannot get any simpler. She voiced an opinion, and she was punished by a representative of the government for that opinion. That said, the judge does need the discretion, but it should be for things actually done rather than speech. If she physically or verbally threatened the judge or his family, for example, comment 4. This isn't black and white, so don't portray it as such. Punishments are handed out based on a person's crimes and their willingness to acknowledge and atone for them. If you show you are disrespectful, you should get a harsher sentence. It's pretty simple, really. We don't need to spend hours deciding whether a judge should be able to hand out different sentences. I think it's pretty clear a first-time offender who is remorseful versus a first-time offender who says, forget you, I'll do what I want, should receive different sentences. Most reasonable, rational people understand that. Story 3. A couple was going through a divorce, and the man talked his soon-to-be ex-wife into a settlement that was supremely beneficial to him. The wife would still be left with plenty of money to live on, but it was still only a small portion of their shared wealth. She signed this deal, and all the man had to do was sign as well, and it would have been done. It would have taken him literally less than a minute. Instead, the man for some reason decided he wanted his day in court, and he was utterly convinced the judge was going to side with him over his wife. Lawyers tried desperately to get him to sign the deal he himself talked his wife into, but he refused and demanded to go to court. The lawyers finally relented, and the whole thing went to court. They were living in a no-fault state, and the woman was awarded 50% of the estate by default. The man lost millions because he wanted a judge to agree with him. Comment 2. One of my mother's friends went through the same thing. She asked for the house and half the retirement accounts, and agreed to let her soon-to-be ex keep nearly everything else: the car collection, the boats, the stocks, vacation properties, and so on. And the husband initially agreed. Not 2 minutes after being given the paperwork, he decided it was unfair. He said he should be able to keep everything, since he had been the sole breadwinner, while all she did was stay at home with the kids. It didn't go so well for him. She walked away with what she had asked for, plus his luxury car, the vacation house in Maine, a check for 7 figures and alimony, and of course he was blameless. It was all because of an activist, liberal judge and his lawyer supposedly colluding with his ex-wife. Story for criminal defense attorney here. Basically every defendant I've ever represented. Sometimes it's stupidity mixed with ego, bad combination. They always think they can outsmart homicide detectives. Those officers have been practicing interrogation skills for longer than the accused has been alive. So many cases turn on a dumb statement to law enforcement instead of invoking the right to counsel. Often, they'll want to talk over the judge and prosecutor when a ruling is coming. That never ends well. You get a lot of these defendants saying, "I'll just go to trial. They'll have to give it to me," meaning a life sentence after trial. Yes, sir or ma'am. They can and they will. These defendants think prosecutors and judges are bothered by going to trial, or will cave with a plea at the last minute. Sometimes it works out for them, but that's a real dangerous gamble to take. Comment 1. Mine was similar. Client found with about 52 grams of illegal substances in his shoe, just above the amount required for a mandatory death penalty. I want to go to trial. They may have found it in my shoe, but my fingerprints aren't on it, so they can't prove it's mine. Comment 2. With a lot of the lower-level offending we come across, we've actually found that defending charges and going to trial works out pretty well for the client. A lot of the time, the prosecution will either get to the day before the trial and want to do a deal or drop the charges altogether. They're just not staffed to give all the criminal files the attention they need, so they often don't realize there are issues with their case until quite far down the line. If our clients had pled guilty at the first opportunity, they would have faced a lot more charges and a harsher penalty than by pleading not guilty. Comment 3. As a prosecutor, I can tell you, I love going to trial. As soon as a defendant sets a case for trial, I revoke all offers. I've seen defendants panic over it because they try to use it as a negotiation tactic. I went to the best trial advocacy school in the country, did a summer at Oxford, learning trial advocacy from some of the best trial attorneys in the world, and took a trial-heavy job because I enjoy trial, not because I'm afraid or bothered by it. Story 5. Obligatory. I'm not an attorney. Disclaimer, but I did use to volunteer for a local program called Teen Court. It was run by the local city courthouse and allowed teenagers who were facing charges for misdemeanor crimes to go through teen court as a diversion program and receive rehabilitation classes and community service rather than time in juvenile detention. The charge would also not go on their record. Teen Court was run by local teenage volunteers after consideration and interviews, and it had an 82% rate for the defendants of never re-offending, which was double the rate for those in juvenile detention in the city. I had one defendant once that I was representing who was an avid skier. I always encouraged my defendants to make a personal statement so that the jury might connect with them more, recognize their sincerity, and go easier on them. The jury has the ability to give up to 100 community service hours, but they don't have to give any at all. Oftentimes, how the personal statement goes greatly affects the time given. My defendant didn't even stand for his, and simply said, "Just know that whatever time you give me is going to cut into my skiing time." He was given 100 hours and multiple classes, which probably added another 20 to 30 hours on top of that. Story 6. I am not a lawyer either, but a good friend is a public defender in Florida. He said he lost count of all the people that he specifically requested not show up to court wearing any drug or alcohol-related clothing, like beer or substance-themed t-shirts, hats, or shiny beverage-branded jackets, for their hearings on driving under the influence, but of course they did. And lots of them also showed up smelling like alcohol or smoke as well. All ages, races, and genders. Story 7. I am not a lawyer either, but my older brother, 50 years old, was at his disability hearing and told the judge, "This whole thing is nonsense. I died 4 times in the hospital and have been declared 100% disabled by 2 doctors. You all are a bunch of idiots in here. It didn't work out so well. He's waiting on the appeal. He deserves the help, but he's also a bit of a fool." I believe his lawyer told him he couldn't come to the next hearing. Not so much ego, as opposed to just being rude. Comment 1. My sister is kind of in the same boat, but not exactly. She is a wonderful and hard-working person. She ran 2 stores for her retailer, the same retailer she got sick from. She told them multiple times she needed to have an office because the air quality was making her sick. She had doctor's notes and everything. They didn't listen, and now she has had a cough for 9 or 10 years. Every day. She will need to be on oxygen by the time she is 50. She has consumed so many cough drops that she has ruined her teeth. She has been declared disabled by multiple doctors regarding multiple different health issues that stemmed from this cough. Her lungs are severely damaged, which then left her with a constant cough, which dropped her mental health, which then raised her blood pressure. I could go on and on about her other issues that doctors say were caused by this problem. She was denied Social Security because the job specialist they called in said she had served tables before and she could still do that. I'm positive people want a waitress coughing 24/7 to serve them their food, right? Story 8. My father was a public defender and was defending a man on trial for arson. A witness said something unflattering about the man she had seen, and my father's client jumped up and shouted, "You can't talk about me like that." I'm Louie the Torch. Story 9. I worked in court mediation, so not a lawyer, and saw many young men arriving with forget authority type shirts on. It was so common that the legal aid team had been to the thrift shop and had a selection of more respectable shirts to lend defendants. But daily, there was always at least one person who thought they knew better than the magistrate and would argue with him or her. It was amusing. My favorite was when the obnoxious young man was told to walk home from 10 a.m. court to change your shirt and your attitude and be back for the afternoon sitting or be arrested and discover the delights of justice hospitality. It was over 30 degrees in Australia. There was only 1 bus per hour, which didn't go all the way there, so he faced a long walk even if he made the next one, and he lived on the other side of town. I believe he was rather subdued when he got back. Exhausted, hot, hungry, and wiser, it didn't stop him from getting into trouble again, but he knew to wear a plain shirt next time. Story 10. Finally, a thread I can kind of offer an answer to. My wife, who is Chinese and was working in an all-Chinese business, was getting harassed at work for months. Finally, it reached the last straw when she got punched in the face by a coworker. The management didn't let her call the police and didn't let her leave. For months before this, there had been verbal harassment and a whole mess of other issues. A few months earlier, I had recorded a phone call conversation with her boss where she had told her boss about the problems, and he said he would fix it so it wouldn't happen again. After this, we got a lawyer and filed a personal grievance, which is basically, I have to quit because it is unsafe to work. After a few months, it finally went to mediation. They had an English-speaking lawyer, but they couldn't speak English. Our lawyer explained all the terrible things that had happened, and at one point he mentioned how there were times when coworkers said disgusting things to her. And I am not kidding, her ex-boss, her ex-boss's husband, and a support person they brought with them all laughed out loud. Their lawyer shot them angry looks in disbelief, and the mediation had to be stopped, so that the mediator could tell them they couldn't do this. They denied everything, but we presented the police report and the phone call, which they never knew we had recorded. 2 weeks later, we settled for nearly $70,000, plus lawyer fees and lost wages. Story 11. Obligatory. I am not a lawyer. I got a driving under the influence charge a few years ago. I know, hate me, but I ran into a kid I graduated with at the accelerated rehabilitative disposition hearing. The kicker is his dad was a judge. I was scared to death. I knew I had messed up. I was in a suit, and I ended up sitting next to this kid who smelled strongly of substances while we were called up to the courtroom in groups of 10 to 15. He was wearing a basketball jersey and flip-flops. Even though that was specifically against courthouse rules, the lower-level people knew who he was and let it slide. We got into the courtroom just for the acknowledgement that we'd been accepted for the program and would have probation and community service. The judge saw this kid and called him out, saying, "Who allowed this kid in here like this? Yes, I know who you are, and I'll be speaking to your father and his superiors shortly after this. His dad is no longer a judge." It wasn't just that incident, but him bailing his son out time after time with his attitude of, "Do you know who I am?" definitely didn't help him. Edit. Oh, regarding the client ego in that story, I think he got 30 days in jail, and I'm sure they gave him the maximum punishment for a low-level misdemeanor they could throw at him. That judge was very unhappy with that kid. Comment 1. I was in court for a traffic thing. I was the defendant. I pled guilty and paid the fine because, yes, I was a fool and deserved it. There were others there as defendants who were in ripped jeans, sequin t-shirts, and flip-flops. Just what? Comment 2. I got pulled over for speeding in Upper Bumbletown, New York. The town was about 90 minutes away from home, so I figured I might as well show up to court to see if I could plead it down. Which I did. The state trooper even said I definitely wasn't the fastest person he had pulled over that day. I wore slacks and a nice sweater. Looking around the rest of the courtroom, I definitely felt overdressed. Comment 3. Dressing nicely, meaning clean, non-wrinkled clothes and freshly washed hair, is sometimes all it takes for a judge to lower the sentence for the little things. Usually, self-respect is the last kind of respect you lose, so the people who just don't care about their appearance are unlikely to care about much of anything else, including the fact that they broke the law. Dress nicely, be polite, and you can sometimes get off with just a warning. Story 12. I am not a lawyer, but I did serve on jury duty. During jury selection, the prosecutor asked if we could vote for conviction based only on the testimony of a single police officer. The defense attorney asked if we knew how many video cameras there were at the airport. The defendant was accused of public intoxication at the airport. The prosecution brought their star witness, an airport police officer who testified that the defendant was drunk at the airport. The defense attorney asked about video cameras at the airport. It turns out your every move at the airport is recorded by multiple video cameras, and the police had those recordings, but decided not to bring any of them to court that day. Remember, defendants, the state has the obligation to prove you guilty, not the other way around. It is way more important what the state does not say than what you could say. At our defendant talked, what could he possibly have said that would have convinced us he was sober at the airport? Story 13. We were working on a Social Security disability case for physical disability. When the judge asked the client about his intimate life, he decided to tell the judge about how he was still fully functional in that area. He cost himself tens of thousands of dollars. Story 14. Every single time, especially in family law, though it happens constantly with my criminal clients too. It's all ego and emotion. I understand why, but you need to step back from the situation and listen when I say you're going to regret making all of your legal choices based on spite. Story 15. So, not an attorney, and definitely not this guy's attorney, but Marshal Ney was tried for treason after Napoleon was defeated. His attorney tried to claim that Ney was technically not a Frenchman, on account of the fact that the Prussians had just annexed his hometown. Ney angrily declared that he was a Frenchman and would remain so. He did, however, manage to gain the distinction of being one of the few people who had the honor of commanding their own firing squad. Story 16. I remember an old Reddit story where the original poster was gay and lived with his husband, who was a firefighter. His mother, a very much homophobic woman in denial over her son's sexuality, snuck onto their property at night and set the house on fire. They lived, but they lost the house, and their dog passed away in the fire. If I can recall correctly, she was caught red-handed and went on trial. Originally, she was going to be tried for arson, but then she proudly admitted that she was humiliated by her son's sexuality, that his husband was a firefighter so they could save themselves easily, and that she did it because it was better to have a deceased son than a gay son. The court took it as a full confession, and she was charged with attempted murder. Her ego got her from an arson charge to an attempted murder charge. Story 17. I represented a very wealthy man in a lawsuit against former business partners. We had undeniable evidence showing they were overstating invoices and pocketing the difference. But my client was extremely difficult. In his mind, no one had any right to tell him what to do. The other side wanted to depose him and offered several dates for it. Normally, the lawyers communicate, find out when their client is available, and submit a simple notice. My client refused to be deposed, even though it was in his best interest. So the judge got involved and ordered him to be deposed on a certain date. I called to tell him, and his secretary told me he had just taken his yacht out and did not tell them when he would return. When I did get in touch with him, he said no judge was going to tell him what to do. The judge deemed all admissions against us, which I thought was improper, levied sanctions, and basically destroyed our entire case. When he finally did come in, he settled with the other party and ended up paying them a substantial amount. But no one could tell him what to do. Story 18. Not an attorney, but I worked in a law firm. We had a workers' compensation claim where a man fell down at work and claimed he injured many different body parts: shoulder, knees, back. We told him to stay off social media. No problem. He didn't use social media. At trial, he told the judge he used to be a spin class instructor, but since the accident he couldn't teach classes anymore. Well, it turned out he continued to teach these classes after his injury. This was proven by the hours of surveillance the insurance company conducted, showing him teaching and vigorously riding in spin class. How did the insurance company know he was still an active instructor? The man posted his full teaching schedule on his social media page. His potentially very lucrative claim was quickly changed to a fraud claim against him. Comment 1: We had a guy claim he dropped a pallet on his foot and broke it during work. Okay, he goes to the doctor and gets a cast. 5 days later, he calls in saying he got the cast wet and had to cut it off. Gets a new one. 5 days later, it was too tight and he cut it off again. I met him at the clinic to be the company representative. The doctor tells him to work into a shoe. We had a private investigator rent office space from us, so we had him followed. A few days later, we had video of him putting up a chain-link fence, alone, wearing a pair of sandals. Of course, we sent that to workers' compensation. He skipped town before he was supposed to meet with them. Story 19. Not my client, but the other attorney's client. The man claimed workers' compensation and threw everything he could at us, meaning he basically listed just over half of his body parts on the claim petition, stating that he injured each one. We knew he wasn't telling the truth. We were going to trial, and the day before, we ran one more social media search. This person posted a video of himself winning a breakdance competition that took place only a few months after the alleged work incident. I've never seen a quicker dismissal in my life. Story 20. Not an attorney, but one client of ours still baffles me to this day. He had multiple cases, including aggravated battery and possession of illegal substances. At the insistence of his family, we worked hard to get him a bond, so that he could get out of jail and live with said family until the case was over. The whole process took weeks. Less than a day after getting out, he was caught stealing $16 worth of batteries from a retail store. His bond was revoked. To be fair, the line between stupidity and compulsion is blurred with this one. Story 21. My wife's lawyer bans all clients from using social media after he lost a big case. It was a wrongful death lawsuit where a man's wife had passed away. It seemed like an easy win. They were about to settle, until the other side found his photos online from a club a week after his wife's passing. In the pictures, he was getting a lap dance while wearing a shirt that said, "I love older women." Apparently, they didn't think he had much pain and suffering anymore. Story 22. One client added 9 years to a short sentence. He initially received about a year or two for being involved in a drag race where the other person crashed and severely injured someone else. Then, toward the end of his short prison term, he tried to escape and got 9 more years for prison escape. He ended up becoming friends with the person who harmed John Lennon in a New York prison, which was an interesting twist. Story 23. Not an attorney, but I heard this story from a guy that I first used to work with. His brother-in-law got injured at work and was suing for a hefty sum. The case was pretty much open and shut. All the evidence was in the brother-in-law's favor. Then the brother-in-law started talking. They asked him to tell them about the day of the accident. He started out fine until he got to the part where he approached the piece of equipment that injured him. He admitted there was a note on it stating that it was out of order. Then he said that he discarded the note and started up the piece of malfunctioning equipment anyway, because he had a job to get done. That easy win was discarded faster than that out-of-order sign. Story 24. The worst ones are the clients who think they're smarter than they really are. When it comes time for depositions, broad sweeping statements like, "I would never allow discrimination in my office," or "I'm 100% sure I never said that," are a great way to destroy your own credibility, set yourself up to get dismantled by opposing counsel, and ultimately turn a small nuisance value case into something worth 6 figures. Moral of the story: if you're going to ignore the entire day of deposition preparation I did with you just so you can protect your own fragile ego on the record, at least do me the courtesy of telling me to leave beforehand. Story 25. I had an instructor who was a prosecutor. He called a witness who had seen the whole thing and had an interest in seeing the defendant punished. It seemed like a slam-dunk case, however. She thought she was on television. She overacted every word and completely embellished the retelling of the events. She didn't lie, but she made herself the center of her version of the events. He said you could see the faces of the jury members sour minute by minute. He lost the case. Story 26. I was defending a client who was accused of trademark infringement. He thought he knew better than the intellectual property attorney assigned to his case, me, so he went on his company's website to defend himself by basically confessing to what he did. He also claimed it wasn't against the law and called the trademark owner a woke baby who needed to learn the law or get back in the kitchen and make her husband a sandwich. I wish I were joking. I was one email away from negotiating a settlement that would have allowed him to continue using the complainant's mark with limited restrictions and a very nominal fee. However, she saw his website, told us to forget about it, and dragged it before a judge. My client lost big time. His lack of self-control cost him thousands of dollars. Story 27. Not an attorney, but I worked in a firm. We had a workers' compensation claim where a guy fell down at work and claimed he injured many different body parts: shoulder, knees, back. We told him to stay off social media. No problem. He didn't use social media. At trial, he told the judge he used to be a spin class instructor but couldn't teach classes anymore because of the accident. It turned out he had continued to teach these classes after his injury. This was proven by hours of surveillance the insurance company conducted, showing him vigorously leading spin classes. How did the insurance company know he was still an active instructor? He posted his full teaching schedule on his social media page. His potentially lucrative claim was quickly turned into a fraud claim against him. Comment 1. We had a guy claim he dropped a pallet on his foot and broke it during work. He went to the doctor and got a cast. 5 days later, he called in saying he got the cast wet and had to cut it off. He got a new one. 5 days later, it was too tight, and he cut it off again. I met him at the clinic as the company representative. The doctor told him to work into a shoe. We had a private investigator who rented office space from us, so we had him followed. A few days later, we had video of him putting up a chain-link fence, alone, wearing sandals. Of course, we sent that to workers' compensation. He skipped town before his scheduled meeting with them. Story 28. Client was part of a group of individuals involved in illegal activities. One of the others caused the death of a boy, while several were involved with harming him. Our client's defense was that he was just a bystander, so although he was present, he was not involved in the actual act that led to the boy's death. He was on bail throughout the trial, right up to the moment when he decided to change his story and instead claim that he hadn't been there at all. His sister gave evidence that he came home that night covered in blood. He received a very long sentence. Story 29. Paralegal here. Once had a convicted criminal explain to me how their charge for causing a death should be overturned because the victim didn't pass away at the scene of the crime. They argued that since the victim died later at the hospital, they couldn't be charged with anything more than attempted harm. Comment 1. This reminds me of the historical case involving President Garfield. He lived for 11 weeks after being harmed, but his doctors became competitive over who could remove the object lodged in his back. They kept probing the wound repeatedly with unclean hands, as this was before germ theory was widely accepted. Garfield eventually died from infection, and his attacker's defense was that he only harmed the man, claiming it was the doctors who ultimately caused his death. He wasn't entirely wrong in that argument, but he still faced the full consequences. Story 30. I am not a lawyer, but I used to review disability claims, so I often worked with clients who had lawyers. A man whose attorney had specifically instructed him not to speak with us directly, an extremely smart and basic recommendation, called me up to rant, angrily claiming that his lawyer was wrong. He insisted he could shop for groceries and mow the lawn and do all sorts of housework just fine, thank you very much. Now, I had seen this man's medical records. There was no way he could do all of that without difficulty. So I asked him to explain further. He clarified that he could shop for groceries if he used a mobility scooter and had his wife carry everything inside. He could mow the lawn if he used a riding mower and took a lengthy break every 10 minutes. He could do housework, which meant wiping down counters and folding laundry, but not carrying it. I called his attorney and gave them a quick update as soon as we hung up. I approved his claim, but that man is extremely lucky he got someone willing to take an extra 15 minutes with him. Story 31. I am a criminal defense lawyer. My client was arrested for driving under the influence. He lived in a small town. He and his wife would drive to the one bar in town, drink, then walk to their houseboat after a night at the bar, about a quarter of a mile away. He and his wife knew everyone in the bar. Another patron they knew got heavily intoxicated, and the bar owner said she couldn't stay. My client and his wife walked her to her car to wait until her ride arrived. My client got her into the back seat of the SUV. He was drunk, dropped his keys on the way to the front seat, then opened the now unlocked front door, turned on the car lights to see. He had walked around the front from the rear passenger side. The police were outside watching for people leaving the bar under the influence. They saw the lights turn on and said they had witnessed driving. They immediately approached and arrested my client. My client had a prior driving under the influence charge from around 12 years before. The judge agreed that it wouldn't come in, and the jury wouldn't hear about it unless my client opened the door during testimony. I couldn't win the case unless he testified. I prepped him, continued prepping him, and told him repeatedly under no circumstances could he say he would never drive under the influence or make any statements like that. Basically, anything about his past was off limits. Direct examination was going well. I gave him a great, easy final question where he could explain the night, express why he was upset about being arrested, since he wasn't driving and was trying to do everything right. Then he said, "I would never do something like that." That opened the door. The judge allowed the prosecutor to bring up the prior driving under the influence case in rebuttal. The jury took about 25 minutes to convict him, and that's just one of about 100 stories. Life is never dull in criminal defense. Story 32. I am not a lawyer, but this isn't my story. The lawyer who handled my business matters and a legal dispute is now a federal judge. Before he became a judge, he was a lawyer for divorces and civil cases. A wealthy male client filed for divorce. There was a prenuptial agreement. It was very solid. It detailed the distribution of wealth, with alimony outlined at a set amount, increasing yearly based on inflation. There was one major exception: if you are caught cheating, defined by any intimate contact with another person before the divorce is finalized, you automatically get the worst terms of the prenup. For the wife, that meant she would receive no alimony and a one-time payment of $100,000. For the husband, it meant losing the main family home, all vehicles that were not his daily driver, and a quarter of his business, with a buyout option available. The lawyer met with his client before court in a conference room. The client walked in beaming, shook the lawyer's hand and said, "Hey Mike, I want you to meet Jasmine. I met her 2 months ago. She's amazing. We got engaged over the weekend in France." Mike shook her hand, slumped into the chair and said, "We've got a major problem. You're cheating on your wife with her. And legally, I have to disclose this information to the other side." The client was shocked and asked, "How is that cheating?" "We're separated," Mike explained. "Cheating is defined as any intimate contact before the divorce is finalized. It's in your prenup, one that you wrote yourself. The client became furious and ended up skipping court, which resulted in a default judgment. That meant she got everything she asked for. Plus, because of the cheating and his absence, the judge ordered that the transfer of money happen within 30 days, as previously agreed. A client wasn't there to contest it. So it was finalized. Later he tried to hide assets by moving the company to the new woman via a trust, which was an illegal move. He also tried to transfer $1.1 million to her through a bank transfer, but the judge found out and required her to return the money since she had been notified as well. He fought for years and ended up losing money, time, energy, his business, his house, 6 or 7 cars, and his new wife. Now, according to his daughter, whom I know through work, he's a retired, bitter man living in rural New Mexico. He can't afford to golf more than once a month, and posts online about how women are terrible. Next morning edit. I didn't expect this to get so much attention. Thanks for the positive messages and replies. I'll try to answer any questions in the thread if I see them. Story 33. I was on the jury for a 3-defendant trial involving a serious charge. We sat through weeks of testimony, and from the sheer amount of direct evidence the state had, it was extraordinarily obvious very early on that Defendant 1 had committed the crime. Defendant 2, who was Defendant 1's brother, and Defendant 3, who was Defendant 1's girlfriend, were much less obvious. We were being asked by the state to consider circumstantial evidence that left most of us feeling like we had to make some leaps to draw the conclusion they wanted us to. That is, until Defendant 3 decided to take the stand. Defendant 3's attorney did a very good job of painting her as the victim of abuse. Her attorney had us feeling sorry for this poor, unintelligent woman who had been groomed since she was 16 by a man 20 years her senior. From the attorney's narrative, Defendant 3 was basically Defendant 1's victim. He controlled what she wore, what she did, and who she spoke to. He even made her get a tattoo declaring her as his property. We saw text messages about Defendant 1 harming Defendant 3's puppy because she had upset him. We also saw texts from Defendant 3 to Defendant 1 cheering him on after he had sent her pictures of the crime scene, but her attorney had us questioning whether those words were just her playing the role of supportive partner to avoid being harmed herself. We were starting to believe she was terrified for her safety, which is why she didn't report him. It seemed reasonable, considering how dangerous this man appeared to be. Then, the other attorneys and the district attorney tore her apart during cross-examination. They made her look argumentative, caught her in multiple lies, and by the time they were done, based on her own testimony, it was pretty clear that she not only knew the victim, but had actually been the one to plan the entire incident. We even started to feel like she probably manipulated Defendant 1 more than he had manipulated her. The other defendants did not take the stand. When we went to deliberate, we all discussed how bad of an idea it had been for her to testify. We decided Defendant 1 was guilty on all counts within the first 5 minutes. Defendant 3's verdict was almost as quick. We concluded that while she did not physically commit the crime, she had conspired and was just as responsible. Defendant 2 took the longest. We all felt pretty strongly that he was involved somehow, but the prosecution had not proven it beyond a reasonable doubt. We had to return a not guilty verdict on all counts for him. Story 34. I had a domestic violence case. For months we went to preparatory hearings, gathered evidence, and obtained restraining orders. By the time the trial was finally happening, on the same morning of the hearing, the person I represented let me know that she had gone on vacation with the defendant for a couple of weeks and had a great time. At that point, the opposing counsel approached me and said they had plenty of evidence showing both parties enjoying their time together during the trip. This, of course, doesn't mean the abuse hadn't occurred in the past, but it really weakened our case, where we had little evidence other than testimonials. I had to explain to her that beyond just the strict legal issues, the judge might change her perspective after seeing that the person requesting a restraining order had recently gone on vacation with the defendant. Story 35. I'm excited I can answer this one. I'm not a lawyer, but I was raised by one. My father did criminal defense for over 30 years in Texas before he took a position with the district attorney's office. Here are some of his best stories. One involved a serious case where he persuaded the district attorney to waive the harshest penalty. The jury ended up acquitting his client on the most serious charge, but convicted him on aggravated robbery, sentencing him to 45 years. The client's family was connected to a criminal organization, and they all, his mother, grandmother, and others, wore Mickey Mouse shirts to court. It was a not-so-subtle reference to their group's initials. The district attorney was very frustrated with how that trial turned out. My father always said he got the better of him in that one. Another case involved a defendant whose brother suddenly confessed to the crime while testifying during the trial, without my father's prior knowledge. Apparently, the defendant and his brother had devised this plan before trial. However, nobody but their mother believed them. The jury still convicted the defendant, and the brother ended up getting charged with lying under oath. My personal favorite story. My dad was defending a client charged with robbery. The client showed up for the first day of court, but didn't come back for the second day. The judge decided the trial had to continue, so my dad had to defend the case with an empty seat behind him. He said you could see the jury feeling sorry for him as he did his best under the circumstances. A few days later, they caught the client in another state. He had robbed a bank and was arrested at the airport while trying to buy plane tickets to Hawaii or somewhere similar. He later admitted that his plan was to steal a boat after he landed, but the absolute worst thing a client ever did to ruin their case? One decided to represent himself in a murder trial. It was a disaster. My father had to sit in the back of the courtroom, assigned as standby counsel. The client was clearly not in a good state of mind, but the trial went forward. The jury ended up giving him a life sentence. The appellate court later overturned the conviction and ordered a new trial. That time, the client wisely chose to have legal representation throughout. He ended up with a 40-year sentence instead.